welcome to this latest session in the Mills Reeve In-House in Focus programme. My name's Alex Newman. I'm your chair for today's session, which is a very grand way of explaining my role, which is essentially to do the introductions, talk you through the obligatory housekeeping, and then helping out with the Q&A at the end of the session. So our topic today is competition law essentials. I'm sure that many of you will know that genuine competition law experts are very few and far between. So it's a real privilege for me in a second to introduce you to my colleague, Kate Newman, who will be talking you through the content. Before I come on to do that, though, I'm afraid there are some housekeeping points that we need to cover before we get started. So the first point, you'll have heard this many times before, we will be recording the session. So it will be available afterwards via our YouTube channel, which you can access via the In-House in Focus webpage on our website if you want to watch the session back or if you've missed parts. What we won't be doing is recording any contributions that you make. We won't be naming any names, for example, if there are questions asked. So don't worry about that from a recording perspective. The slide deck as well, I believe, will be available after the session. Questions, Q&A will do at the end of the session, if that's okay with everybody, but please do feel free to ask questions as we go along, and then Kate will, with me helping her along with the questions, answer those at the end of the session. Could I ask that if you do ask questions, please use the Q&A box in the toolbar at the bottom of your screen. Please don't try to use the chat box, because you won't be able to, because that's kind of been reserved for the host panel. So please do use the Q&A box, and we'll get through as many of those as possible. There is always the possibility that we won't get through all questions, so if you're comfortable about doing so, please do leave your name when you ask your questions. That's only so that we can answer your questions after the session if we don't manage to answer your question during the session, and we can do that directly. Importantly, obviously, from our perspective, is getting feedback. At the end of the session, there will be feedback options for you to contribute to. Let us know how you think we've done, whether the content was of use, and also really important for us to hear about any ideas for future sessions. It's really important for us that the topics we cover are topics that are of genuine interest to you, and we really need some feedback and some suggestions to make sure we get that right. So please do take the time to do some feedback. There will be some polls during the session for you. So Kate will ask some questions and ask you to I think yes or no answers as we go along, to gauge reaction and gauge perspectives on a couple of the points that she'll be raising. I think that's it for me for now. I babbled on for long enough. As I said, my great pleasure to hand over to Kate Newman, who will talk you through competition law essentials.
Thank you, Alex. Good morning, everyone. So in today's session, we are going to cover the following things, which are up on the slide. So I'm going to just spend a couple of moments recapping on the key elements of the UK's competition rules. I'm then going to talk about enforcement activities by the Competition and Markets Authority, including a very recent development about how the CMA has said it is going to be approaching enforceability of rules in relation to sustainability agreements, a hot topic at the moment. I'm then going to talk about trends in UK merger control, and finally, to give you a little bit of a heads up on some upcoming reform of the UK's competition regime. So if you could move on to the next slide, please. So by way of a very brief reminder, competition rules are intended to safeguard free and fair competition between undertakings. And undertakings, as many of you might know, mean an entity really of any kind or description which carries out an economic activity, so not just companies and businesses. And the rules prohibit the conduct of undertakings in effectively three ways we're going to be looking at today. So first of all, agreements and practices between independent undertakings which have the object or effect of preventing, restricting or distorting competition in the UK or part of it, which I'll be referring to today as the Chapter 1 prohibition. Secondly, the rules prohibit the abuse of a dominant market position if it may affect trade in the UK or part of it, which I'll be talking about in terms of the Chapter 2 prohibition today. And finally, the rules also prohibit mergers, which may result or be expected to result in a substantial lessening of competition within a market in the UK. And the idea being that with the benefit of free and fair competition, we as consumers have the benefit of lower prices, more choice, better quality, and increased innovation. So next slide, please. So if you get it wrong, however, and if you breach the rules, the following could happen. So you could face a lengthy investigation by the Competition Authority and potentially eye-watering fines of up to 10% of group worldwide turnover. There could well be damage to your reputation, or if you're a listed company, impact on your share price. You could face other costs, internal costs, in terms of dealing with the competition law investigation or inquiry, in terms of distraction from day-to-day business, impact on management time, and so on. You might also face a damages actions from third parties for losses incurred as a result of a breach. Agreements which are infringe the rules are void and unenforceable, so a commercial impact there. And for individuals who are involved in the worst competition breaches, so cartel type conduct, they could face criminal penalties. And directors of companies who have infringed the rules could also face a director disqualification order. So the stakes are high. I just wanted to set the scene extremely briefly about the status of UK competition law post-Brexit, because this is relevant to what I'm going to be talking about as we go through the slides this morning. So I suppose just a brief reminder, so in this post-Brexit world, EU competition law will no longer apply in the UK, but UK undertakings who trade in the EU will continue to be subject to the EU competition rules. In this new environment, both the CMA and the UK courts are bound to ensure consistency between UK rules and pre-Brexit competition case law in the EU, although the CMA and the courts do have a discretion to diverge from that in appropriate circumstances, which include, for example, differences between UK and EU markets and developments in the form of economic activity. I think what we can take from this is that, at least in the short term, UK competition law will remain closely aligned with EU competition law. I mean, EU and UK competition law have been closely intertwined for at least 40 years, and I think it's inconceivable to think that that will change dramatically in the very short term. But I do expect there may be at least some gradual divergence in the medium to long term, and we'll see how that might happen as we go through the slides. So if we could move on. So I wanted to talk to you today about enforcement activities by the CMA, and I thought I would start just by giving you a current snapshot of what is going on. So the CMA started 2023 with a very substantial volume of work on its books in terms of enforcement activity. It had 13 ongoing Competition Act 1998 investigations across a range of industry sectors, covering both the Chapter 1 prohibition and the Chapter 2 prohibition. And to give you a feel for the industries which are under scrutiny, ongoing cases include construction, retail, digital communications, the motor industry, financial services, recreation and leisure, pharmaceuticals, and healthcare. So the focus of the CMA has been wide, and as I said, covers both the Chapter 1 and the Chapter 2 prohibitions. Of these 13, I think it's quite notable that 6 relate to cases by large digital companies. So this is the CMA focusing on protecting competition and promoting innovation in the digital sector. So very much aligned with what we're seeing in terms of enforcement activity elsewhere in the world, including in Europe. And the CMA is also defending 13 appeals before the Competition Appeals Tribunal relating to infringement decisions which are taken in relation to cases in the pharmaceutical sector. These have been a very long-running series of cases where the CMA has investigated conduct which it has found led to market exclusion, and also by dominant companies, excessive and unfair pricing. And we expect some of those appeals to reach their conclusion this year. So next slide, please. As well as focusing on companies, the CMA has also been very active in focusing its efforts on driving deterrence through its use of director disqualification orders. So as I mentioned earlier, if a company has infringed competition law, the CMA can seek an order disqualifying a director from acting as a director of any company for up to 15 years, or it can accept an undertaking to that effect. And this includes not just directors, but also former directors of a company and also shadow directors. It includes a situation where a director's conduct contributed directly to a breach, the director's conduct did not contribute to the breach, but the person involved had reasonable grounds to believe that there was a breach taking place and didn't do anything about it, i.e. turning a blind eye, or the director did not know but ought to have known that the conduct was a breach. So again, very broad. Since 2016, there's been a real policy change on the part of the CMA to use these powers really to drive a deterrent effect in the economy. And I counted up that 17 directors have been disqualified since that time, and there were a further 7 applications on foot regarding a recent infringement decision in the pharmaceutical sector. So no signs there of the CMA slowing down with that policy drive. But what's coming next? So next slide, please. So the CMA published its annual plan in draft just before Christmas, setting out its short and medium-term priorities over a 3-year period. So this is a very good way of getting a steer of what the CMA is thinking about in terms of where to focus its actions. And specific priorities for 2023 and 2024 included continuing to clamp down on cartels and other collusive behaviour that stop public bodies and private households making the most of their available budget. So you can see here clearly a recognition on the part of the CMA of the squeeze on living costs and the public purse, and a clear indication that it will continue to take enforcement action and that the rising costs of living and other squeezes in the supply chain will not be permitted as a means of facilitating or reason for companies to collude and coordinate their behaviour. So next slide, please. So in this, I suppose, vein of thinking about how the CMA can protect against harm, I think it's really interesting that the CMA has shown an interest in possible breaches of competition law in the HR space. Now, traditionally, the CMA and other competition authorities have largely focused on conduct relating to price fixing or market sharing, for example, between competitors concerning the supply or purchase of goods or services. So HR really hasn't really been in their sights. But there is this wave of interest which really recognises that competition has a role to play in labour markets. So in other words, companies should compete for workers just as much as they compete to sell their products or services to customers. So anti-competitive conduct in the labour market therefore could really harm competition, not just in terms of the competition for employees or consultants, but also could flow through into reduction of competition in those downstream markets as well. And this is, I suppose, a concern which might have been prompted in a post-COVID environment where there's been a real focus on supporting economic recovery, but I guess also has come to the fore given the current war for talent in many sectors of the economy. So in July 2022, the CMA launched its first formal investigation into suspected infringements of the Chapter 1 prohibition relating to the purchase of freelance services supporting the production and broadcasting of sports content. The concern being that the companies involved offered freelance workers such as camera operators, sound engineers and so on, a flat rate for attending matches, regardless of the duration of the shoot, the distance travel or popularity of the game. So that is on foot and we'll wait and see where that goes. It's also very noticeable that in other places around the world, the same concerns are being investigated. So we can see that in France, Greece, Hungary, Lithuania, Poland, Portugal, Romania, and the US. And we think there might also be some focus at the EU level. There has been this real clampdown on wage fixing and non-solicitation or no-poach agreements between competitors. So it's a live issue, and I would say watch this space because I think more will be coming. So next slide, please. In terms of key takeaways then, I would leave you with the following thoughts. So I would expect that active enforcement by the CMA is expected both in 2023 and beyond. I think the CMA will be focusing on sectors with a close consumer nexus or sectors which impact on public spending. I think we can expect to see an increase in dawn raids, so unannounced inspections by the CMA, particularly after the hiatus of COVID, both in terms of physical dawn raids, so that's when the CMA turns up at your premises or possibly at your home, or equally by, virtual dawn raids by sending out formal requests for information. And also, I would expect other authorities around the world to also be gearing up their enforcement activities. As I just mentioned, here in the UK, but elsewhere as well, there's an expanding focus on novel harms to competition. So now is a pretty good time to dust off your policies and procedures to check that, for example, your HR policies cover the type of conduct and practices that are currently under investigation, and also to check that your people understand the parameters of what is permissible from a competition standpoint in the HR space and what is not. And finally, it would also be a very good time to dust off your compliance programme to check it is still effective and fit for purpose, and if necessary, give it a refresh, because implementing effective compliance measures really is your first line of defence of mitigating your exposure to risk. So next slide, please. I wanted to mention very briefly, and this was not part of the sort of original scope of the session, but some new guidance which is expected on environmental sustainability agreements. And this is a topic that's been debated at length around the world in the competition community. There's been a real concern that industry collaboration, which might be very important to achieving environmental sustainability goals, is being stymied or prevented by competition laws, and specifically the risk that by participation in these collaborations, companies might find themselves exposed to the risk of enforcement and possibly also fines. In response to this kind of call for clarity and call for action, in a speech at the end of last month, the CEO of the CMA announced that the CMA will be issuing new guidance in the coming weeks in draft for comment that aims to provide businesses with clear and easily applicable advice about how to navigate through this area. The CMA has said it will effectively be giving guidance in 3 scenarios. So first of all, those scenarios where the firms really just don't need to worry at all about competition law because competition law isn't going to be an issue. Secondly, those scenarios where firms can be confident that an environmental sustainability agreement does not result in an appreciable restriction of competition. And thirdly, the third bucket, so where an agreement relating to environmental sustainability may restrict competition, but nonetheless may be permitted because it would qualify for an exemption on the basis that the benefits which flow from the agreement outweigh any loss of competition. So next slide, please. So the CMA has said that guidance can be expected on the kind of benefits that will be relevant to that exemption analysis, and moreover, what kind of steps businesses will need to think about how they can actually demonstrate that consumers will derive a fair share of benefits from an environmental sustainability agreement. And the CMA has also indicated that it will have an open door and that it will be willing to provide advice to businesses who are considering entering into agreements of this nature but are unclear about whether or not those agreements might give rise to an issue. So I think that is quite a significant step forward. There is, of course, though, always the risk that environmental sustainability agreements can be a smokescreen for collusive behaviour which falls foul of the rules. And in the speech, the CMA was very clear to say that it will not tolerate spurious environmental claims being used as a cover for anti-competitive practice. So there is still a warning there that you do need to be careful to make sure that things are set up correctly and moreover do not spill over into conduct which might cause a concern. So that's another area to watch in the coming days. So next slide, please. So we're on to the second major topic for today. So this is around UK merger control I'm going to just take a couple of moments to give you a brief recap as this sets the scene for the slides which follow. So by way of reminder, in the UK, a merger will qualify for review where you have two or more enterprises, so businesses, which cease to be distinct, and the UK turnover of the target exceeds £70 million, or the merger creates or enhances a share of supply of 25% or more of goods or services of any reasonable description. So that's called the share of supply test. As many of you will know, the UK's merger control regime is voluntary. There's no requirement to notify the CMA about a qualifying merger, but the CMA is pretty active in monitoring deal activity. And if it does become aware of a transaction where it thinks it has jurisdiction and there might be competition concerns, it can call in a transaction for review. So next slide, please. So in that scenario, or when parties choose to notify the CMA carries out an initial phase 1 investigation. That's 40 working days. At the end of that, the CMA has a duty to refer a transaction for a detailed phase 2 investigation, which would be 24 weeks if it believes that a merger could give rise to a substantial loss in competition. Parties can offer undertakings at that time to avert a phase 2 investigation. And at the end of a phase 2 investigation, the CMA could either clear a merger unconditionally, give clearance subject to undertakings, or it does have the power to prohibit a decision outright. So that's the backdrop. So next slide, please. So let's look at the trends in UK merger control at the moment. So I think this is really interesting. So in the last 6 months of 2022, it seems that the proportion of phase 1 cases that presented competition concerns had increased significantly compared to the same period in 2021. So in that 2022 period, 28% of cases were referred to a phase 2 review. That's a really significant proportion. And 44% of cases involved undertakings in lieu. At the time those stats were prepared, that means that undertakings were either accepted by the CMA in lieu of a reference, or they were being considered. So a really high proportion. In the same period in 2021, only 21% of cases were referred to phase 2, and only 9% involved UILs being considered and accepted. So you could see quite a step change in the number of cases causing concern. So this could suggest that the CMA is becoming much more interventionist. Alternatively, you might say that this indicates that the regime is actually working quite well, in the sense that the CMA is looking at deals which genuinely do present potential concerns. It might also be reflective of the deal environment and where we are seeing transactional activity taking place. So I think that's a really interesting statistic to bear in mind. And going into 2023, the CMA really has a very substantial workload in its mergers unit. It has had 23 ongoing phase 1 merger cases and 9 phase 2 investigations. And since 1st of January 2023, 5 new phase 1 cases has been opened. So the CMA is pretty busy. Next slide, please. So here are a few trends I wanted to mention to you. So first of all, the expansive approach to the share of supply test, which I mentioned a few moments ago. So in the UK, as is the case elsewhere, there has been a real concern for some time that existing merger control rules have an enforcement gap and have not worked well in terms of catching high value, low turnover deals, sometimes called killer acquisitions. So this describes a scenario where a startup, highly innovative company is acquired, often at a time when they really don't generate any turnover and therefore fall below the thresholds. And the concern here is that by missing these transactions, deals have gone through which have actually stifled competition by taking out from the marketplace a source of possibly significant potential future competition. The CMA has been bridging this gap by applying the share of supply test in really quite a flexible way. The CMA has always had a discretion in how it's applied the test, but we've seen really a step change in the CMA in appropriate cases, really kind of expanding the way it has looked at that test. So, for example, in 2019, this was in the pharmaceutical sector in a case concerning Roche and Spark Therapeutics. The CMA asserted jurisdiction over Roche's acquisition of Spark, even though Spark did not actually generate sales at all in the UK. The CMA found jurisdiction on the basis that the parties' combined number of UK-based employees engaged in R&D in the relevant product area, as well as the number of UK patents procured from an administrative patent authority. So quite a wide interpretation of the test here. And whilst this has been a kind of policy change for the CMA, as we'll come to later, there are legislative changes proposed which will aim to really bridge this gap by putting a change onto the statute book. And I'll come on to that in a moment. Secondly, I wanted to mention interim measures. So when conducting a merger investigation, the CMA can impose interim measures really to freeze or unwind integration between the parties, or even to prevent preemptive action. And the purpose of these measures is to ensure that the CMA's investigation is not prejudiced, or the ability of the CMA to impose remedies at the end of its investigation, if that is regarded as necessary, is not prejudiced either. So these interim orders are taken very seriously by the CMA. I'm sure anyone on the call who's lived through a process with the CMA involving interim measures will have had that experience. The CMA can impose penalties of up to 5% the total value of turnover for breaches. And it does impose penalties. It's not a hypothetical risk. The CMA is very active in monitoring compliance and does impose penalties where it finds breaches. So in financial year 21-22, 4 penalties were imposed in respect of alleged breaches. And there are fairly significant sums of money. So £350,000 imposed on Ion Investment Group. Meta received 2 fines totaling 52 million in respect of its completed acquisition of Giphy, and combined fines of 4.7 million were imposed on JD Sports and Foot Asylum for infringements of the interim measures applied there. So the CMA has said in its guidance that actually its fines, whilst large in monetary terms, they say fall some way short of the 5% cap, but the CMA has said it will impose proportionately larger penalties in future cases in order to drive deterrence. So this is a live issue for anybody engaged in transactional activity involving the CMA. And finally, picking up on the theme of Brexit, now that the UK is outside the one-stop shop of the EU merger regulation, this means that transactions of a particular size, so a size which meets the EU merger regulation but also triggers the UK thresholds, may well face parallel reviews both in Brussels and here in the UK, and that could give rise to complexity by way of divergence of approaches of the authorities. And initial experience has suggested that, again, that risk of divergence is real. So, for example, there have been examples of cases which have been cleared unconditionally in the UK, but have required remedies in the EU and vice versa, meaning that it is more difficult to plan for a kind of smooth regulatory process. So next slide, please. So just turning to the annual plan for 23-24. I'm sorry, there's been a fire alarm. I'll carry on, I'll see what will happen. Again, with the focus on people being confident of getting great choices and fair deals, the CMA has indicated it will be focusing its merger control activity on important sectors, and it's mentioned vets and dentists, to make sure they're not subject to anti-competitive mergers. Vets and dentists are called out. There are live cases at the moment because these are rapidly consolidated sectors, again with that consumer nexus. Looking forward, and I don't have a crystal ball, but I would expect that other important sectors which will be scrutinised would include tech and digital, really with that sort of innovative sort of concern about driving innovation being in hand. Healthcare, I would suggest, might be another area. So-called green mergers, so where mergers might reduce competition in areas which have environmental impacts. And I'd also call up the food sector as well, given its close consumer nexus. And again, the CMA has some live cases in that respect. So key takeaways. Next slide, please. Thank you. So the CMA continues to be active and interventionist, which I think you could see from the statistics I mentioned earlier. And the face of merger control here in the UK is changing, but that's a trend which we're seeing elsewhere as well, which means that planning for deals is more difficult and really, I would say, expect the unexpected, which means really that as much planning that can be done at an earliest possible stage is time well worth spent, really, which might include more proactive consideration of remedies in appropriate cases to make sure that the deal can be delivered in a smooth manner. So onto my final section, and just a quick review of what's coming down the line in terms of reform. So the government stated in the autumn statement that it intends to bring forward the Digital Markets Competition and Consumer Bill in the current parliamentary session, which will result in some important changes to the regime here. So first of all, I'll just mention this very briefly. There will be the implementation of a pro-competition digital regime for digital markets, which will include placing the Digital Markets Unit on a statutory footing. That unit has been in place, sort of sitting within the CMA for some time, and it will have the role of regulating digital companies with a designated strategic market status through conduct requirements and targeted pro-competitive interventions. It's similar to the Digital Markets Act, which has recently been implemented in the EU. So next slide, please. In terms of mergers, this is actually where we do see some really interesting changes. So in terms of the jurisdictional test in particular, so it is proposed that there'll be an uplift in the turnover test from 70 million to 100 million. This is to account for inflation, so large deals. Importantly, and that's the second box along the first row, a new jurisdictional test has been proposed, which will apply where one party has both a share of supply in the UK of 33% or more and UK turnover of £350 million or more. So this only applies to one company. It's intended to bridge that enforcement gap I was talking about in terms of killer acquisitions, and may mean, though, for some larger companies who have a material market share, that merger control will be a live consideration in all transactions, whether or not they fall into that killer acquisition territory. And a small merger safe harbour is proposed in the cases where each party's UK turnover is £10 million or less. And I think that would be welcomed for SMEs because that test is much clearer than the current de minimis test, which I won't get into now. There's some indication that there might be coming down the track further reforms to the share of supply test, and some reforms are also proposed to deliver more effective and efficient merger investigations. Anyone who's lived through a CMA merger investigation knows that it's a long process, and therefore reforms to drive, I suppose, some expediency through that, I think, would be welcomed as well. Next slide, please. So finally, there have also been some proposed reforms to the way that the CMA can conduct its enforcement activity. So there will be a change extending the reach of the CMA to enforce UK competition law, really enabling the CMA to enforce agreements implemented outside the UK, but which have an effect on trade in the UK. The CMA will be given new evidence gathering powers to interview individuals as part of its investigations, a power to seize and sift evidence when it inspects domestic premises under a warrant, and stricter duties on companies to preserve evidence. And finally, and this is a step change, new powers to impose much more significant penalties on companies who fail to comply with a formal CMA investigation request or who provide misleading information. At the moment, fines are currently capped at £30,000 plus the possibility of daily penalties of £15,000 for as long as non-compliance continues. Under the new proposal, fines of up to 1% of annual worldwide turnover could be imposed, so really very significant. And also there are proposals that a natural person who fails to comply with an investigative measure could also receive a fixed penalty of up to £30,000, and again with a backup of daily penalties of up to £15,000 whilst non-compliance continues. And this is really intended to create more effective deterrence. The CMA has been concerned for some time that companies simply are not complying fully with their formal investigative powers, and this is really intended to drive that deterrence effect. So that's everything I had to say today in my presentation. I think we have I hope some time left for questions and a time left for our poll as well. So Alex, over to you.
Yeah, thanks.
Questions?
Yeah, shall we do the poll questions first? Yeah, and then
yes.
I've just had a couple of questions pop in, so I'll read them while you're doing the polls, and then I'll convey them to you so you can give answers to those.
So these are yes/no questions. So this is the first in-house in focus session focused on competition law. So I'd be really keen to understand what kind of content would be of interest to you going forward. So if you could let me know, would you be interested in a competition law session which covers, for example, option 1, managing a dawn raid, option 2, a more detailed session about merger control and investment screening in the UK, that wasn't something we touched upon today, 3, a deep dive into recent legislative changes, for example, the vertical agreements block exemption order, or 4th, would you be interested in hearing more about competition law and how it interacts with state sustainability objectives? That's poll 1. And poll 2, would you welcome more international content in competition law sessions? Today's session was very UK focused with a few references here and there to what's going on elsewhere. But again, it would be really great to hear from you about whether sessions which draw in more international content would be of interest. Recent legislative changes wins, but still quite high responses for the others. So thank you. And a yes to more international content. So thank you, that's really interesting. And Alex and I will take that away for future sessions.
Yeah, thanks everyone for contributing there. We do have some questions, Kate, that have come in just towards the end of the session. So I'll start at the top. Yeah. So for mergers, how is the market share of the merged company determined? And is advice typically given on that by financial advisors, lawyers? How is that process undertaken, determining the value?
So market shares for a company is actually really sort of an economic exercise which looks at well, first we have to work out what the market is, and that's really an economic exercise. I'll make that first point, which looks at demand and supply side substitutability. And then in terms of how you actually determine the market shares, I mean, that can be done on a number of different bases. Financial advisors often have access to very good statistics and data, but equally, the lawyers can feed into that as well by, I suppose, giving a view on how previously markets have been analysed by the authorities and whether sort of calculation of market shares are robust and likely to be accepted by a competition authority. So in short, I would say it's a joint endeavour with input coming from different people. And of course, input from the business is always very important as well, because they know their business best out of everybody.
Thank you. I'll move on to the next question, which, yeah, very pertinent, and I can absolutely understand why the question's been asked. During a phase 1 CMA merger investigation, what can and can't be done between the merging parties whilst that investigation's underway?
Yeah, very good question. Again, very important. So until a merger is cleared, and assuming the question's been driven by a trade acquisition, where the buyer and the target are competing with one another or potentially competing with one another, you have to be very, very careful to make sure that informational discussions do not take place which infringe the Chapter 1 prohibition. You'll normally see in a SPA, for example, in the interregnum provisions, the ability for information to flow from target to acquirer which really are aimed at, I suppose, ensuring that the target value is preserved in the target, and to give the acquirer some comfort on that. But anything really beyond, which goes to, say, joint marketing or jointly approaching customers or discussing pricing in a post-transaction world, would be very dangerous. So that is an area where, advice is something you need to think about very carefully. So that would be my sort of very short and sweet answer. Which is different, and therefore it's always well worth thinking through it on the facts. But that would be my golden rules.
Okay, thank you. We have a question with a football context, so I'm going to ask that one. Do you think that the current financial scandal at Manchester City could somehow trigger competition law issues, particularly, for example, in relation to player transfers in the context of the kind of the HR arena that you were talking about earlier?
Well, I have to confess, I don't know much about the current financial scandal at Manchester City, so I'm afraid I can't really add anything specific about that. But I would say, sport and football would not be outside the purview of the competition rules, and certainly given the focus on sort of wage fixing and the like, and competition for labour, it's not beyond the realms of possibility that that could fall within the sights of the CMA. Some of the other investigations I mentioned on that slide about HR actually did involve football, actually, in other places. So it's a possibility.
Okay, we've actually had quite a lot of questions come in now. We're not going to get through all of them, unfortunately, but what I'll do is I will focus on the anonymous questions so that we can then feedback with answers to people who have left their names with their questions. So one of the anonymous questions is, from your experience, does there remain a collaborative and open approach between the UK and EU authorities, or has the relationship been impacted due to Brexit?
Well, the withdrawal provisions did foresee there being a possibility for collaboration. There is no formal kind of memorandum of understanding as yet, as between the UK and the European Commission. However, I think there are some sort of green shoots which we can look at, which indicate that there is, I suppose, scope for collaboration. So there's an ongoing cartel investigation into the motor industry, where the EU and the CMA are investigating, as I understand it, much the same practices in terms of end-of-life vehicle recycling. And my understanding is that there has been collaboration between the authorities on that case. So nothing formal as yet, but I would expect that in the global world, that we should expect to see some kind of formal collaboration put into place in the sort of short to medium term.
Okay, thank you. I think I'm very conscious of time, and we do have a number of further questions, but I think we're unfortunately going to have to feedback in relation to those separately. Yeah, we are running out of time, so I'm afraid we'll wrap it up there. A couple of things before we finish. Feedback, as I said at the start, is really important to us to understand how you've received, whether or not you've found the content useful. And obviously, as I mentioned earlier on, suggestions for other topics that we can cover in these sessions would be most gratefully received. A couple of webinars coming up to put on your radars. Invitations will be sent for registration shortly. We'll be having an immigration update on Wednesday, the 1st of March. And then, as you see there on the screen, on the 22nd of March, a session on IR35 and employment. That will be a refresher. That will be a kind of covering some ground we've covered in a previous session. But for those who have missed it, or those who would like to hear a lot of that content again, that option is available. So, as I said, yeah, invitations to register will be sent around shortly. And for now, all I think that remains for us to say is thank you very much for your time. Thanks for attending. It's always a privilege to have so many people attending these sessions. It makes it really worthwhile for us to know that they're so well attended. So thank you, and we'll see you next time, hopefully.